to one or more than one system of law. So connecting factors such as domicile, residence, religion, or customary affiliations are used. So one of the most complex areas in Nigerian conflict of law concerns the position of the native Muslim. A native Muslim may be simultaneously connected to customary law by ethnicity and Islamic law by religion. So determining the personal law applies in matters such as marriage or succession. Determining which personal law applies in matters such as marriage or succession often depend on the court's assessment of the individual's dominant personal system. This dual affiliation illustrates the practical difficulties that arise from legal pluralism in Nigeria. So among the significant issues in the change is the change of personal law system. Yes. So along the line as a person grows, you have instances where a person changes his personal law system. Either he or she that changes by marriage or conversion to Islam from Christianity or adoption of a different way of life, basically, or even total abandonment of a particular customary law system or practice. And then the conditions under which a change of personal law is recognized remains unsettled. So because the person has been seen to have changed does not mean that automatically the personal law system that will apply will be the law that changes. It is such that will be scrutinized as to whether the person actually adopted the system that he has changed to and whether that system is actually fair. Like I said before, part of the things the court will consider is if it's certain and fair. So basically, this paper examines the personal system of law within the framework of conflict of law in Nigeria. It focuses on how personal system of law operates in matters of personal law, how they give rise to legal pluralism, the connecting factor used by courts to determine applicable law, the special case of the native Muslim, and circumstances under which a change of personal law may occur, with particular emphasis on customary law. The objective is to show that while legal pluralism is an accepted feature in Nigerian law, its effective management depends on clear conflict of law principles. So what is personal system of law? Like I said particularly earlier, that a person's personal system of law is the law that applies to the person based on the person's characteristics. You have the person's status as a characteristic, you have the person's capacity, you have the person's personal relationship based on who the person is rather than where the person is located. And like I said earlier, where the person is located is usually governed by the statutory law. So personal law follows the individual and relates to matters such as marriage, divorce, legitimacy, succession, and family relations. The idea of that certain aspect of a person's life are best governed by the law that reflects their social, cultural, or religious identity rather than a single uniform law. So what are we saying? Basically, what we're saying is as a result, two persons may be governed by different personal laws in relation to a particular subject matter. I, being a Nigerian Yoruba Muslim, may be governed by a different law in relation to a succession matter from a Nigerian Yoruba Christian, by virtue of the fact that the personal laws, there's first the customary law, that's on my part, being a Yoruba, and then there is the Islamic law, being a Muslim. Those are personal laws that follow me wherever I go, unless I change, that's convert, or I totally denounce it, or as I've stated earlier. So basically, Nigerian courts therefore rely on the concept of personal law to resolve disputes involving personal status and family relationship. The courts do not apply personal law arbitrarily. Instead, they identify the legal system that has the closest connection to the individual concerned. In essence, a personal system of law is the legal framework that defines a person's private legal life within a personal legal order. Its recognition in Nigeria reflects the country's social diversity and forms the foundation of legal pluralism in personal law matters. So, recognition of customary law and Islamic law. In Nigeria, the Constitution specifically recognizes that we are a multi-ethnic and multi-religious nation. So we have numerous ethnicity and then the religion is numerous. So this on its own recognizes legal pluralism. There's also the provisions for Sharia law They are the courts, the customary and Sharia courts by virtue of Section 277 of the Constitution that have been established, particularly because of the multi-ethnicity and multi-religious nature of Nigeria. So despite this recognition, the coexistence of multiple legal systems presents significant challenges, particularly when customary and Sharia laws appear to conflict with constitutional principles. So yes, there are especially those enshrined in fundamental rights provisions under Chapter 4 of the Constitution. So basically, there are some instances where there is an overlap between the principles of the doctrines under the customary law, as it is, and then the principles as enshrined in the Constitution, particularly Chapter 4 of the Constitution that talks about the rights of people. There are some times, like take for instance the issue of some customs not allowing female children inherit, and that was determined in a case, particularly the case of Agbai versus Okogwe, where the Supreme Court ruled that discriminatory practices under customary law must be subject to the constitutional guarantee of equality. So the Supreme Court in that case held that regardless of whatever gender the person may be, the person should be able to inherit by virtue of equality, all equal for the law.
Yes.
Yes. So, that is the end of chapter or part 1. I'll move on to part 2. Now, part 2 talks about operation.
Virtual lecture. Virtual lecture.
Can I continue, sir?
Continue, please.
Yes, sir. Part 2 then talks about the operation of personal system of law in personal law matters. Now, what are personal law matters? Like I stated earlier, we have the marriage, we have the divorce, we have inheritance, we have legitimacy and legitimation, and then we have succession. Those are typical personal law matters. So we'll be looking at each one of them and looking at what the state of affairs is as relates to customary law, as relates to the constitution as statute, and then as relates to the religious aspect, that's the Islamic law. Now, marriage. In Nigeria, marriage is recognized under the 3 legal systems, that's statutory law, customary law, and Islamic law. Each system has its own requirements for the validity of marriage, and this can create significant conflicts, particularly in cases where a marriage is celebrated under one system but subsequently litigated under another. A statutory marriage is governed by the Marriage Act, which follows the English model of monogamous marriage. This type of marriage is formalized through civil ceremonies, and once celebrated, it comes under the jurisdiction of the statutory law. So as we all know, statutory marriage recognizes one man, one wife. Unlike the customary marriage and the Islamic marriage, customary marriage recognizes a man having multiple wives, polygamous marriage, unlike the statutory marriage. Then the Islamic marriage recognizes that a man can marry up to 4 wives, which is unlike the customary and the statutory marriage. So what then happens when a man marries under the customary marriage, and then the subsequent marriage he wants to make under the act, wants to make statutory? So the law generally is that for a marriage that's particularly under section 33(1) of the Marriage Act, says that no marriage is valid if either party is already married under customary law to someone else, thereby preventing a valid statutory marriage from taking place while an existing customary marriage is in effect. Furthermore, Section 35 prohibits individuals married under the Marriage Act from contracting any subsequent customary marriage while the initial statutory marriage is valid, effectively ensuring that only one marriage is recognized at a time. So those are the issues that arise in terms of marriage. Then there's the popular case of Olowu and Olowu. A classic example of such conflict is the case of Olowu and Olowu, where the Supreme Court had to decide on issues relating to the validity of a marriage contracted under customary law or challenged under statutory law. In that case, the court had to navigate the complex interplay of both legal systems to reach its decision. The Supreme Court decision on Olowu and Olowu reaffirmed this position that Nigerian courts have generally held that if a statutory marriage is contracted, it takes precedence and any subsequent marriage under customary law or Islamic law will be invalid. Then moving on to the case of divorce. As I stated earlier, under statutory marriage, it is regulated by the Matrimonial Courts Act, which already has prescribed modes of marriage and divorce. Divorce under the Matrimonial Courts Act says that such a marriage has to be broken down irretrievably on a number of various grounds. We have the grounds of adultery, a number of grounds under the Matrimonial Courts Act. And in the event that it is a marriage that is a divorce that is by consent, you have the bride has to have waited, the woman has to have waited for like 2 years, and then the consent to be given for it to be registered as a divorce, or 5 years if there's no consent. But that is not the case under customary law or Islamic law. Under customary law, there are some marriages that do not even go through a rigorous process. All you need is a group of people coming together to talk about the marriage and decide, okay, is this what's going on? Is it not going on? What have you done? And then there's the return of the bride price as well that can also indicate that the divorce has been concluded. But under Islamic law, what you have is a very different and distinct mode of divorce. You have the husband using the pronunciation of the talaq, as repudiation of his wife 3 times, and then there's divorce. But for the women, if the woman is the one to initiate the divorce, she has a number of processes that she has to go through. To show you the difference, this is just to show you the difference between an Islamic divorce from a customary divorce and a statutory divorce. So in cases where statutory law and Islamic law intersect, courts have been tasked with resolving the validity of divorce process. A notable example is the case of Al-Kamawa versus Bailey, where the court had to decide whether a divorce conducted under Islamic law was valid in the context of statutory inheritance proceedings. The court upheld the divorce under Sharia law, recognizing the importance of respecting the personal law of the parties involved. So basically, if they are contracted under Islamic marriage, the courts are more inclined to respect the divorce via that method, since a statutory marriage already has its own process of divorce. So we'll move on to inheritance. Inheritance under statutory law is governed by the administration of estate law, which generally follows the English system of intestate succession. However, customary law and Islamic law provide distinct rules on inheritance, particularly regarding the distribution of property after death. So, like we said, administration of estates governs those for statutory marriage. You have the children of the same blood, before you have the children of our blood, before you have the parents, then before you have the spouse, we have siblings, spouse, parents, like that. But under customary inheritance rule, they vary across the multiple ethnic groups that we have. Like in Nigeria, you have the Oriojori system, you have the Idigi system, depending on whichever one they choose, the family chooses to apply. Then I don't know. Sorry, I'm also informed about other ethnic groups. But in many cases, yes, then in many cases, in many ethnic groups, you have instances where they say the wives or the female children or the daughters cannot inherit the property, and that in itself leads to conflict of law system. So, like I said before, having the mix of a customary law overlap with statutory law in itself constitutes a conflict of law, because the courts are then called to determine which law would apply. We have the principles under the Constitutional Chapter 4 that says that everybody is equal. And then you have some customs saying that because you're a criminal child, you cannot inherit. I mean, they're already conflicting. And then in the event of a conflict, of course, the Constitution will be supreme, because the courts, like I said before, will use the principle of fairness to determine what is just if the personal system of law does not seem just. So you have the case of Eden and Eden, where the Supreme Court was asked to advocate between conflicting customary and statutory inheritance law. Court ruled that statutory law took precedence where the deceased had contracted a statutory marriage, emphasizing the importance of recognizing equal inheritance rights under Nigerian law. Now, the case is different for Islamic law. Under the Islamic law, you have, by virtue of the Quran, you have the Quran saying that men inherit more than women. Yes, they inherit male inherits typically inherits double the share of the women. And then there's a particular case of Olabanji and Ashafa that illustrates the tension between Islamic and statutory inheritance rule. In this case, the court had to determine the proper distribution of estate of the deceased Muslim, balancing the requirements of Sharia law with the statutory framework governing inheritance. Now, legitimacy and legitimation. But just a point to note is basically if the law is not found to be unfair, unjust, or against the principles that are enshrined in the Constitution, then the statute is generally not against it. I mean, since that's the personal law of the deceased. Now, legitimacy and legitimation. Now, the issue under legitimacy and legitimation is, I'm sure we're all aware of what legitimacy and legitimation means. We're talking about where you have children out of wedlock. Now, for the statutory law, there are instances where children that are born out of wedlock can safely inherit from their father. However, under the customary law, there are some instances where because of his illegitimacy, he cannot inherit. And this conflict was addressed in the case of Amadi and Unsu, where the Supreme Court upheld the right of illegitimate children to inherit under statutory law despite conflicting customary practices. So basically, Nigerian courts play a critical role in resolving conflicts that arise in family law, particularly in cases involving marriage, divorce, and inheritance. In many instances, courts have developed principles to guide the resolution of these conflicts, focusing on fairness and protection of the fundamental rights as enshrined in the Constitution. So one of the key principles used by Nigerian courts is the principle of lex loci celebrationis, which holds that the laws of the place where the marriage was celebrated should govern its validity. This principle was reaffirmed in the case of Onwudinjo, where the court held that a marriage contracted under customary law in Nigeria should be adjudicated according to Nigerian customary law, even though the parties had since moved to a statutory jurisdiction. Another principle often invoked is the doctrine of forum convenience, which allows the Nigerian courts to assume jurisdiction where it is most appropriate to hear the case. This principle was used in Agbede and Agbede, where the court held that it was the proper forum to hear a divorce case. A divorce case, despite the fact that one of the parties was resident abroad, the court emphasized that it would be inappropriate to subject the parties to competing legal systems, and that the Nigerian courts were best placed to it was the best place to apply Nigerian law. So in inheritance dispute, Nigerian courts have often prioritized statutory law over customary or Islamic law, especially where the deceased contracted a statutory marriage. This was evidenced in Law and Law, where the court held that statutory marriage regime superseded conflicting customary inheritance rules. Similarly, in cases where customary law excludes female heirs, courts have frequently invoked constitutional principles of equality and non-discrimination to override customary practices, as in the landmark case of Mojeku and Mojeku, where the Court of Appeal struck down a customary law that excluded female descendants from inheriting properties. Now, succession. In many jurisdictions, general rule of both testate and intestate succession is that in the absence of the applicable English or local statute, the personal law of the deceased, especially the customary law to which the deceased was subjected, is the governing law. This excludes the law of the place where the deceased resides.
Hello? I
Yes,
thought
sir.
you said somebody will present other parts of the paper. You alone.
Yes, sir. This is the last part for part two. This is the last part for part two. It's just this succession is the last part for part
You
two.
are reading it now. You are not talking to it. Okay,
Okay,
go
sir.
on.
Yes, sir.
You have
So
6 minutes
basically the issue
more
of
from your time.
okay, so basically the issue of succession is on when a person dies, is property, what would happen to the property? Is his property going to be devolved on the next person by virtue of his personal system of law as at a particular time? when he was giving birth to, or the personal system of law that he used at the time of his death. All this, like I said earlier, is dependent on if the deceased actually adopted the system of law that he was known by before his death. If he merely just changed location, the court would not term the law governing the location at that time the law to use in terms of succession. Instead, the law will look at what what personal system of law was dominant to the person before his death. There are several cases. In the case of Takwa and Kuka, the deceased Enupe from Bida, in the then Nigerian Providence Estate, living in a house in Lagos. Both parties have agreed that the applicable law for determining who was entitled to administer the estate was the deceased personal law, the Enupe customary law, not the prevailing, not the law prevailing in Lagos, being the law where the property was situated. So instead of the law where the property was situated, they agreed that it was the law that the deceased used as a personal system of law that will be used as a succession, as the law governing the succession. A number of cases, also the case of Gamson and Wobil, where the woman was the previous owner was a Fanti woman, although the land was situated elsewhere. It was held that the Fanti law would apply instead of the law where the land was situated. So I think at this point, I'll just leave it for the next speaker because of time. Thank you.
Well, at the rate we are going, maybe the comment on this paper will have to be next week. Go on.
Okay. Please, next speaker should take over.
Let the next person take over.
Good afternoon, sir. My name is Badruddin. I'll be speaking of part 3 and 4 of the paper. Because of the limited time, I'll be brief. So part 3 talks about the connecting factors for personal system of law. Essentially, the idea of having connecting factors is because Nigeria is a country where you have plural laws applying to individuals side by side. So it became important that aside the territorial law that applies to all Nigerians, we then have individual laws that personally applies to citizens of the country based on certain factors. So in order to have that, in order to determine what law will apply when it comes to personal matters, as the first speakers had highlighted earlier, it became important to have certain connecting factors that connect, that gives a reason why you should apply this law to this person. So that is actually the reason why you have connecting factors. So by virtue of common law and based on what Nigeria had gotten through the received English law, the primary connecting factor is the domicile. So domicile essentially is saying you should apply the law for personal matters. You should apply the law of the law where a person resides and where a person that resides in that place has the intention to permanently reside in that place. So in order to apply to use domicile as a connecting factor, you have 2 elements you have to consider. First one is residence. Where do you reside? And second, do you have the intention to permanently reside where you are residing? So we've seen in the case for second and Passman where Thomas J had held that it is not only it's not necessary that you're actually residing there. You must have a permanent intention to reside there. So if you are probably just residing somewhere habitually without the permanent intention that this is where I'm going to be living forever, you may not be able to refer to the domicile as a connecting factor. So that's the general view. So by operation of law, there are certain ways in which a domicile can be conferred on persons. So you have domicile by origin. I mean, where you are birth, domicile by birth or origin, or domicile by origin. You can either call it both. It means by what is held in common law, a domicile has to attach to someone at birth. So it means that where you are giving birth to, you automatically take so where you are giving birth to, the law of that place so will apply to you. That will be your domicile. So, but when you then go up and then you come under the 2 elements that we are talking about, you moved away from where you were giving birth to and then you then moved somewhere else and you had the intention of staying there permanently, then you then take the domicile of that place. So we also have domicile by dependence, where you have um, a new child at birth is is inheriting domicile of his father, and then a newly married wife, is also taking domicile of the husband. So, but where you have a situation where the wife had divorced the husband, so it changes. So she no longer takes that domicile. And also, when you have the child growing up to 21-year-old, the person can then go to have his or her own domicile. Also, where a child is given birth to without, maybe a bastard where you can't find the father, the child will take the domicile of the mother. So domicile is the primary connecting factor for Nigeria based on common law. However, there are other certain connecting factor where you have residence. Residence is actually where the person actually lives and lives on a very long term, and probably so it may not have that permanent intention to stay there, but the person lives there. So we found that where it will amount to injustice to apply domicile as a strict connecting factor. So the court have applied residence where it will not amount to injustice. So residence only requires that, okay, you've been there for a very long period of time. So you also have nationality as a connecting factor. For Nigeria, it's going to, so this comes to play mostly when it comes to international scenario where you have people of different countries, because in Nigeria everybody is Nigerian, so you don't really see it play at full length. So where you have intra-state or intra-Nigerian situations, you then apply other types of connecting factor, because essentially everyone is in Nigeria. So you also have modern connecting factor. So you also have the connecting factor of ethnicity, customary law that attaches to citizens ethnic group, where by virtue of where you are from, the customary way of life and law that applies there would apply to you. So that's also a type of connecting factor. And then you also have modern connecting factors like habitual residence, where habitually, by virtue of probably work or certain other reason, one person has stayed or always stays in a particular place or lived his life there. However, we've seen that this has not really completely been adopted in Nigeria, but it's sort of a modern connecting factor. And then you have the religion also as a connecting factor. As the first speaker earlier said, you see that she made mention of people who are Muslims and how the court has interpreted what or had held what connecting factors they will use to determine what law applies to you. Because you see a lot of cases where the judges would say, because you are Muslim and you've lived your life as a Muslim, you then have your religion to determine what law applies to you in certain personal matters. So we note that generally in applying these factors to people when they are in courts, particularly, you don't have one straightforward deciding connecting factor, because you have citizens that sort of fall into different categories. So the courts are always very careful to ensure that they adopt domiciles depending on the circumstances before them, because they acknowledge the fact that the country is a country where you have plural laws and applying at the same time to same persons, and so they collectively apply these domiciles based on circumstances. So I'll move to the next chapter, which is the native Muslim and threats of personal law. So this essentially, in summary, because of time, this is just talking about how one can be a Muslim and also, so you fall under the connective factor of religion, and also you fall under connective factor of probably customary law. And so the court is at dilemma. There's dilemma of what law then applies to you. So we've seen that because we have Nigeria as a multi-religion country, and also because the constitution, which is the ground norm, has recognized religion as, there is no religion discrimination. Everybody is free to practice whatever you just want to have. So you then have a religion like Islam, where you have a lot of you have the Muslims living their life as prescribed by their books. So the court has come to say, okay, we're going to respect your religion. We are going to give our decision in certain matters, when in personal matters, in line with what your religion has provided. So then you also have the constitution creating courts like Sharia courts, which goes to the fact that, yes, they recognize the fact that people live their life, particularly in the north, they will live their life according to how it has been prescribed in religion. So they have to be, their matters has to be decided according to what you have said. So we've seen that in cases where you have religion and customary law at when you have both applying to same person, got to mostly apply the religion as connecting factor. However, for instance, in cases like marriage, where you then have a Muslim that get married, that does court marriage already, that goes to the court to marry, and then you know that by virtue of that, it ranks above the religious connecting factor. Then you then have to apply the Marriage Act to determine matters that are relating to that. And then also you have summary. The court, particularly in Al Kamawa was Bello, where the court had held that Islamic law operates as a distinct legal system, and the court must apply appropriate Islamic school of thought that are relevant to the parties. So essentially, that's the summary. It's usually the case that the Islamic law is applied to people that had lived. So when the court is now at confusion, you then that maybe you have someone who had lived his life according to that is actually a Muslim and also has certain customary law applying to him. Because we then look at the life of that person, that has the person actually been living his life completely in accordance to Islam dictates or customary dictates. So whichever way is higher, the court tends to go to adopt that as a connecting factor. So essentially, that would be the summary of both 3 and 4 of our paper, and then I'll let the next speaker talk on chapter 5. Thank you.
Okay, thank you very much. Thank you, everyone. So I'll be speaking to chapter 5 and chapter 6 of our paper. And chapter 5 is talking about change of personal systems of law. We are focusing on customary law. Then chapter 6, it's the conclusion and recommendations. So chapter 5, change of personal system of law, focus on customary law. We know what customary law means, and it has been described as a mirror of acceptable usage. So governing daily life, social relationship, and local matters, such as marriage, inheritance, and etc., etc. So the striking characteristics of customary law is that it's flexible, it's unwritten, and it evolves over time. So meaning that it is the prevailing customary law because it's the way of life of the people. So not an ancient customary law that the people involved do not no longer practice that we are talking about. So by customary law, by its nature, it's inherited through birth, and the speakers have been talking about the connecting factors. So it's inherited through birth and applies automatically when a person belongs to a community where a particular custom is accepted as binding. So it's easy to know the customary law applicable to a particular person, especially when he settles among his own people where he's being born. But it gets complicated when he leaves his location. However, the court has heard that change of location or change of settlement does not automatically translate to change of personal law. You can see this in Yunusa against Hadeshu Bokon. So how then do we what do we mean by change of personal law? So when we talk about change of personal law, we are talking about that a legal system which first applied to a person at birth is replaced with another legal system because of a significant change in the person's situation. So the court, just like I've said, that change of location does not automatically translate to change of customary law or change of personal system of law. The court will look at assimilation and intention. And by assimilation, we are talking about, you know, we are by assimilation, we simply mean that the person is has changed to a new community or legal system to such an extent that reflects a new identity and intention. So it means that the person has been, has been assimilated into a new system or a new community, such that his way of life or how he wants his affairs to be governed, or how he has indicated that his affairs should be governed, has shown a new identity, and the intention is it's clear. So we will see this in the popular case of Olowu against Olowu. So what happened in that case is that a Yoruba man of Ijesha origin, he relocated to Benin and settled there. In fact, he built house there and married a Benin woman. So even during his lifetime, he applied to the Oba of Benin for naturalization, and it was granted. So that makes him to be subject to Benin native law and custom. So upon his death, the issue of determining which personal law we apply at the time of death, the High Court held that he had voluntarily adopted Benin law, making that law applicable to him. So this decision was upheld at the Court of Appeal and at the Supreme Court. So we see in that case that that man has actually assimilated the new culture, and he has shown during his lifetime the intention to be bound by that particular culture or custom. So let me go to the customary law, statutory law, and legal uncertainty. We have earlier said in our paper, the previous speakers had said that Nigeria is a plural system where you have the English common law, statute of general application, which later accumulated into our act or statutes, and you have it running side by side with customary law and also Islamic law. So, and these laws, they govern different aspects of status and class, such as inheritance and marriage, and they have different results, which the earlier speakers have been able to show us. But for instance, now, just to bring about an issue of uncertainty, for instance, because of the nature of Nigeria, we have many people who are, when they want to get married, they get married in court or in registry, but that does not actually translate to the fact that they have changed their personal system of law. So in this circumstance, the court So in this circumstance, it may not be easy to really identify when a person has changed his personal system of law, because the court will need to decide if this change reflects an actual change in personal identity or simply a choice of marital framework. So that's the summary of chapter 5. Let me go to chapter 6, which is talking about conclusion and recommendation. So in conclusion, we have been able to establish that Nigeria is a plural state, and because of we have different personal laws running side by side the statutes, it creates some level of uncertainty and conflict in the administration of justice, such that courts are often required to decide which personal law applies to a person or transaction. So these decisions are not always straightforward, and different courts may reach different conclusions even when faced with the same facts. So it means that this weakens predictability and makes it's difficult for individuals to know their rights and obligation in advance. So the issue of this is even complicated by the fact that someone can change his personal law. Someone can change his personal law, so it makes it more complex. So overall, while legal pluralism allows Nigerians to reflect social diversity, it creates some serious challenges for conflicts of law. So our recommendation, we've number one, that we've recommended that there should be we should develop clear judicial guidelines. We should develop clear judicial guidelines. So this includes setting standards for evaluating connective factors such as religion, residence, and mode of marriage. The number two recommendation is strengthening legal awareness. Just like the example I cited earlier on, that someone can conduct marriage in the registry, but his way of life does not show that he actually intends to, to change his personal system of law. So then number three, harmonize personal laws where possible. We can harmonize personal law where possible. Although we have different personal laws, but there are some cases that they are common and such can be harmonized. Then lastly, that we should encourage alternative dispute resolution. Conflict in this regard has Conflicts in this regard have always been in respect of relatives. So, and then there's this usual adage that you don't go to court, come back to become friends because of the adversarial um, administration of justice which we have. So ADR will actually go a long way in resolving conflict issues. So thank you very much. That's the end of our paper.
Yeah, we've listened to their presentation. Can we have a comment? Comment from the student. From all indication, my own comment will be the first thing I will do in the next lecture. But let's have your comments.
Thank you, sir. Can I go on, sir?
Yes, please. Please go
Okay.
on.
Yeah, I discovered that in the first presenter that still continue with the error, despite the fact that we pointed it out at the last presentation, referring to consistency, talking where there's a conflict with law with the constitutional provision, referring to Section 4 of the Constitution. Now, we haven't learned that it is inconsistency and not constitutions. Now,
Not conflict.
Yes, I would also like to let them to put light into what the first presenter means by saying under dissolution of marriage, when he was talking about the grounds, when you say marriage has broken down irretrievably and made mention of where consent of the parties. I need clarification of what they mean by the place of consent in dissolution of marriage under the Act. Thank you, sir.
Okay.
Can I respond?
Yes, please.
Okay. In respect of the dissolution of marriage, I believe it's section 15(2) of the Matrimonial Causes Act that talks about the grounds for divorce based on the principle that the marriage has broken down irretrievably. Then the one that gives the time frame, it says 2 years if the both parties consent to dissolution after 2 years. of one of the parties living apart, then the court will grant the dissolution. But if there is no consent, then it will be 5 years of one of the parties or both of the parties living apart without any issue of consent. I don't know if I answered that question, sir. And this is according to the Matrimonial Courses Act. Yeah.
I don't think there is such provision in the Matrimonial Courses Act. That's my worry.
Okay.
Maybe you can avail us the section.
Okay, let's look at it. When we come back next week, we will see whether the assertion is correct or not. Any other comments?
Sorry, my name is Amaka Gampuye. I actually think the what she's trying to say is that where the respondent in a petition for dissolution of marriage, where the respondent does not object, then 2 years living apart continuously serves as a ground, and then 3 years is not conditional. You do not need the respondent's objection. It's actually 3 years, not 5 years. It actually falls under the grounds under section 15.
Grounds for divorce.
Grounds for
Grounds
divorce.
for
Yes,
dissolution
yes,
of marriage.
yes, bro. Yes, bro.
All of you are just teaching me family law. The presenters have done a lot teaching us comparative family laws, looking at the differences in the personal systems of law. So they are teaching us comparative family law, not comparative conflict of laws. When you tell me that female and male don't share equally in Islamic law, that male will take twice the female. You now tell me that under Benin customary law, for example, there is no such rule. The rule is that the eldest male child, claims the Gyogbe. And then you now tell me that under the administration of estate law of every state, the wife and the children of the marriage inherit in particular order. What you are teaching me is not conflict of laws. It is comparative family law. You are comparing what the position would have been if the general law would govern, or if Islamic law would govern, or if Benin customary law would govern. You have educated me, but you have not taught me conflict of laws. This is a conflict of laws class. So it is very important to always know what we want to hear. Okay? I always say that, okay, we started our definition of this subject area by looking at the dimension. And we said that it could be international, it could be interstate or internal. It is the internal that we alternatively call legal pluralism some of the time. And what is the meaning of legal pluralism? Was it just yesterday that I corrected the jurisprudence class that people not familiar with conflict of laws will look at legal pluralism as plurality of sources or plurality of laws. Every country has plurality of sources. There is no one, especially if the countries of the common law stock. There is no country that you go to that will say the only source of their law is their legislation. They will have other sources. Sources that will likely be unwritten, that will develop from usage. Even the common law and equity in England is an unwritten source. It evolves as a technique. But you now have body of principles that you can say are principles of the common law or of equity, which without which you do not have the complete sources of English law. The same way in Nigeria, you have plurality of sources. But plurality of sources is not legal pluralism. It's not legal pluralism. You can have plurality of sources, but the sources may not discriminate in their application to people. Imagine in England, despite the fact that there are Muslims in England who are domiciled in England, the law, the statute established for conduct of marriage will not discriminate between Muslims and non-Muslims. So everybody who is connected with England will not be able to do a polygamous marriage. He will not be allowed to argue that, but I'm a Muslim, my religion permits me to take more than one wife. That is because, though they have plurality of sources, they don't have legal pluralism in the area of marriage. So when you talk about legal pluralism, you must define it on a subject by subject basis. In a country like Nigeria, despite our being a legal pluralism, you cannot be talking of legal pluralism in a whole lot of subject areas. You can't talk about legal pluralism in most of public law. I would have said the whole of public law, but for the fact that the Sharia states found a way of introducing Sharia penal code. The Oyinbo man, when he wanted to abolish customary criminal law, all he had to do was to provide in the constitution that nobody will be guilty of an unwritten crime. So you won't charge anybody for, say, adultery, which is a customary law crime. Because adultery is not a written crime. There is no black and white of the law prescribing it. But the Sharia states, what they simply did was to legislate Sharia. And that is why today you are going to have dual criminal law. Okay? I just talk about the law of blasphemy. Every state has a law of blasphemy. Every state has a law of blasphemy. But the Sharia states, apart from the general law that they have in their penal code or whichever code they have now enacted the Sharia concept of blasphemy, which prescribes a different punishment. Now, everywhere where you have a genuine legal pluralism, the problem you always have, I have highlighted them. I've said there are no more than three. The first one is amenability. Since you now have more than one system of law on the same subject, okay, it means that neither of the law operates on a territorial basis. So that whereas in England, the statute regulating marriage will govern every marriage, including that of Muslims or non-Muslims, and natives or non-natives, and whatever. In Nigeria, you have a marriage act that will specifically tell you that everything I'm saying relates to one form of marriage. So in other words, it is excluding the other form and allowing it to be governed by another system of law. That's legal pluralism. So you have some provisions in our statute regulating some subject area. The moment the legislature concludes its prescription, it will tell you analogous transaction done under customary law is exempted. Look at our statute on limitation. Expressly, while regulating time and whatever for limitation, it will provide that those provisions will not apply if it is a transaction done under customary law. That's how you know that there is pluralism on a subject. Okay? And so, when there is a pluralism, on what basis do you identify who is governed by one and not the other? That's the first problem you have in a pluralism. And I saw that some of the cases you analyze are cases touching on that problem. Okay? The second issue, I will go over them again next week because I want to leave in the next 1-2 minutes. The second issue is change. Suppose you are allocated a particular system of law at birth. How does it cease to be the law that will apply to you? What can happen? Suppose you are attached to the system by birth. You can't be born twice. But what have the cases said about possibility of change? If it's a religious law, it logically follows that you must remain a member of that religion. We have seen English cases where two Muslims who had gone into potentially polygamous marriage abroad, okay, for their domicile in England. The moment they change their religion, the English court will say the marriage ceased to be potentially polygamous because the only reason why they had capacity to do that was because they were Muslims. When they cease to be Muslim, they lose the capacity. Okay? So those are instances of change. We are supposed to look at them. We are supposed to look at cases treating them. Then the third question is just like a contract could have connection with more than one state, so that you have to determine which of the two or more states law will govern. It is also possible that two people amenable to two different systems of law within the same territory would have a relationship that has to be governed by law. So you also have a problem almost identical to conflict of laws of the international and interstate situation, except that this one has no horizon. Both of them are in the same legal district. But it is that legal district that permits them to have different system of law. Now, they have merged the systems by transacting with one another. The merger is not going to be determined by the constitution. It's going to be determined by choice of law rules. It's going to be determined by choice of law rules. Whether it is a relationship between persons who are not even amenable at all to customary and Islamic law, and persons amenable to one variant of customary law or another. When a dispute arises from that, the court cannot just crack his head and say, I will apply this one. it is choice of law rules that the court will apply. That is the one that our high court laws sometimes attempt to regulate. But whether those statutes have regulated it in an informed manner is another issue. So those are the three questions. Okay? Because it is quite possible for more than one system of law to operate in the same legal district on a subject matter. How do we determine amenability? Who is amenable to one? Who is not amenable to the other? Two, you have to be amenable to one system of law at least. Is it possible when once, by whatever formula we are using, you are already amenable to one law, for us or the court to recognize that no, you are no longer amenable to that law, you are amenable to this one now. Okay? In the interstate and international conflict of laws, we will say either a country is using nationality or domicile. And therefore, if you change your nationality and the foreign court uses nationality, the foreign court will recognize that the law governing you has changed from that of your former nation to your present nation. If the foreign court uses domicile, the foreign court will say if you have changed your domicile, then you have changed your law from the law operating in the domicile you were before to the law operating in the new domicile. But in this one, the situation is peculiar because territory is not an issue. You belong to the same territory. So how is it possible for you to be deemed to have left one system of customary law for another, or customary law as a rule to general law, or one system of customary law to Islamic law, or vice versa? That's what it addresses. And then the third question, what it addresses is, okay, I'm a Muslim. Islamic law, I have not entered out of it. But I have just entered into a marital relationship with a non-Muslim. What law will we say will govern that relationship? So we have to have choice of law rules too, like they have choice of law rules in the international and interstate dimension. So we will continue the discussion next week. I've even done more than what I should do. They would have started the tafsir I want to go for. So I see you next week. I see you next week. I think we are too
Thank you, sir.
slow.
Thank you so much,
Thank you,
Prof.
Prof.
Prof. Thank you, Prof.
Thank you, sir.
Thank you, Prof.
Thank you,
you.
sir.
Yeah.
Thank you, sir. God bless. Thank you,
Thank you.
Prof.
Thank you.
And thank you all. Good night.